technical difficulties on our end. And we're busy letting everyone into the room. Okay, so today I was asked to speak on municipal bylaws and how they affect property development. It is a topic that is difficult to address when the target audience is a bit of a national audience. This is because the varying municipalities across South Africa, while there is a lot of overlap between their bylaws, there are differences and fragmentations then between those bylaws that affect property development. So what I ended up landing on was discussing somewhat the overarching principles from Splumer, and then boiling it down to what's currently happening at a provincial level, where province is putting in some amendments to their Planning Act, and then going down further into a municipal focus, and then on to specifically the city of Cape Town. And so if I can just share from my end. Okay. Okay, looks like that's all good. Okay, can I get a thumbs up to just confirm that everyone is seeing on their side the necessary slides?
We can see.
Okay, fantastic. Okay. So starting basically with the Western Cape Land Use Planning Amendment Bill. Now, nationally speaking, when it comes to property development, one of your main areas of regularization is the land use planning. And land use planning is first of all governed from the top nationally, being the Act Splumer, which is your Spatial Land Use Planning Act. This gives you a very broad overview of how this is supposed to be regulated and managed within South Africa. Then provincially, provinces can put in their own planning legislation as well, which gives another layer of sort of your guiding principles in development, property development. And then you go a layer down to the municipality who has the delegated authority in terms of a constitution or our constitution to put in bylaws in place to regulate planning and within planning in respect of development of property within South Africa. And in order to address sort of first of all a wider audience, I wanted to discuss the latest proposed amendments to LUPA, which is your Western Cape Land Use Planning Act. And to dive into that, some of the interesting items that I found that should be discussed or brought to everyone's attention. And in short, the first one I want to discuss is validity periods. Now, every or most municipalities across Africa will, within their planning bylaw, have validity periods for development applications that have approved or been approved for their developments. So this essentially means that your developer or property owner applies to develop their property, right? The municipality gives an approval to that application, and their bylaw will indicate a validity period with upon which an owner is to act in terms of that conditions of approval. Should they not act within that period, those set of conditions lapses. Now, from my experience, most of the times, these validity periods as set out in the bylaws are sitting at either 2 to 5 years, and then with an additional option to apply for an extension of 2 to 5 years for your conditions not to lapse. What we find happens every now and then is with clients that, or with developers that operate within various municipalities, there does appear to be from time to time an error in which they don't pay attention to or miss that the individual municipalities have differing periods. And because of that, they end up thinking they have 5 years, or they have applied for an extension thinking that extension is 5 years, but it's only 2 years. And then they run into the problem of either by the time they're ready or able to act on those conditions, the approval has lapsed. And that is obviously problematic because it means they essentially have to make a new application to the municipality to get those rights in place again to develop on the land. And now, what the latest proposed amendment is that the validity period will have to form part of the conditions of approval and not just be a standard clause within the bylaw itself, right? And also with one of those changes is how to lock in the rights of your respective conditions of approval. Now, this is one of the fragmentations that you can get within the municipalities. So, for example, how you lock in your rights is obviously you comply with your conditions of approval, putting your services in on site, and then most municipalities will have an indication that you lock in your rights by a registration at the deeds office. The difference is that some municipalities will link that registration at the deeds office to a transfer of an earth or land unit within that development in order to lock in that rights, i.e. the validity period no longer applies when it comes to lapsing of the rights. City of Cape Town and other municipalities that I can recall at the top of my head, George, they have it linked to also pulling out a certificate of registered title. So not necessarily transfer to a third party, but a landowner or developer taking out a title deed for one of the urban within his development. And that also locks in the rights. So one of the changes within this land use planning bill is to propose that an amendment wherein the rights are locked in by way of certificate of registered title. So that is a nice change because in practice, it does help out the developers that this is a form that they can lock in their rights, because taking out a CRT under your own title for yourself is easier than making sure that you're always ready with a transfer to a third party. As most of us will know that doesn't always, it's not always an easy requirement to meet, because there's another party that you basically need to have at the table, especially if you are in a time crunch to register and lock in your rights prior to the lapsing of a 5-year period. Now, moving on, there is also certain changes to zoning requirements, changes to subdivision applications, where they're somewhat trying to separate a requirement for rezoning when submitting your subdivision applications, which is a bit of an interesting one. Then a bigger change, which is the amendments to removal of restrictive conditions. So this, in my opinion, I am reading as province taking a positive step towards reducing red tape, in the sense that I don't know what everyone's experience is when it comes to removing title restrictions, but as it currently stands, generally it is quite an onerous procedure. So if I can give an example, you have a title deed condition on your property, wherein it says your property, you can only build one house, or you may not subdivide your property. And under the current mechanisms in most municipalities, when you want to make application as a landowner to remove those restrictive conditions, there is a requirement, there's a number of requirements to submit notices to all parties that can be affected by that title condition. And under the current interpretations and current regulations, because the title condition was historically put in place when a developer developed an area or suburb, or when the municipality approved the development of an area or a suburb, you are required to send notices to every single one of those owners that you, indicating that you intend to remove that condition of your title deed. Now, if it's a small area or suburb, your notices could be a handful of owners that you need to notify. If it is a large development, a large suburb, where it could be up to 100, 200, or 300 owners that need to be notified, it does become very costly and very expensive in order to issue those notices for a client. Now, what the current proposal is doing is trying to remove that requirement of having to notify sort of every single person. And they're trying to draw it down to notifying those materially affected parties. So this would reduce it down to the materially affected parties of what you're trying to do, i.e. more likely to be your neighbors and surrounding owners within your street. So it is reducing notification, how many people you do need to notify. It doesn't bar those other parties from commenting on your application or what you're trying to submit, but it is putting a lesser burden on the landowner in making an application to remove a title restriction on their property. Another change that goes with it is how these conditions are, or what is taken into account when assessing the removal of the restrictive condition. So essentially, there is a removal of requirements that was initially set out in LUPA, and then brought forward into majority of the bylaws of the various municipalities. And essentially, that was section 39 sub 5 of the Western Cape Land Use Planning Act. And this required taking into account social benefits, financial benefit, all these other sort of factors in weighing up in the municipality's decision to remove a restrictive condition. Now, for me, I would say that didn't make much sense, and I'm glad to see that this is a positive move in trying to take out those considerations when an owner is trying to remove those restrictive conditions. What I can say is that it should be noted that the City of Cape Town has in their bylaw already removed reference to section, or as a consideration, section 39.5 of LUPA. So they've already themselves moved on. It would now be the need for the other municipalities also to make this change. But it essentially means that this is a reduction on burden on owners for when they are trying to make application, one, through notices, and two, reasons and motivations being supplied for the removal of your condition also now change, because there is no longer these additional considerations that you have to address and motivate on when trying to remove your condition. Okay, and then the next item that I want to deal with is additional items that were added on as what the municipalities can add in your conditions of approval. One of the items added in there is inclusionary housing. Now, inclusionary housing is a very broad topic and a very important topic. What I can start to say with on that is I think it was October 2022, the provincial government put in a inclusionary housing policy framework. And that inclusionary housing policy framework was intended to filter down through all the municipalities within the Western Cape for them to formulate their own policies as to how inclusionary housing should take part within their land use planning. And I would say that this obviously stems from court applications and court cases wherein it was challenged in court that the municipalities have the duty in terms of the National SPLUMA Act, your Spatial Land Use Act, to address spatial justice or injustice. And the courts did find this argument as in the positive, and that is sort of what filtered through the framework being developed, and therefore now needs to filter through down to the municipal policies. At this point in time, I am only aware of Stellenbosch formulating such a policy, which came into effect, I think it was in April or May 2023. There are a few developments that have been affected by that policy, and there have been inclusionary housing opportunities that have already been built and occupied within a development or two within Stellenbosch. This amendment now in the Land Use Planning Act would permeate down into the bylaws itself. And it would then put the municipalities sort of, in my opinion, on the back foot if they haven't formulated their individual inclusionary housing policies in helping them set out the necessary conditions in a land use application or the approval thereof. So with this probably coming through within the next year or so, it will be interesting to see how many of the municipalities actually issue and move forward with their inclusionary housing policies and how they will include it into their bylaws. So overall, I do think quite a number of the amendments put into place or proposed amendments, which is not all captured here, is achieving some sort of red tape reduction. However, there are other places where there is new red tape coming into place, which is why I've noted the Preservation and Development of Agricultural Land Act, which essentially sets up another sort of planning tribunal when dealing with agricultural land. And that planning tribunal also has to put out its own sort of spatial development framework or zoning scheme. And the municipality, when developing theirs, are mandated to take into account what is being put out by that structure set out by this act. And then I just want to move on to the difference between property zoning and title restrictions. So this is something that is applicable to South Africa as a whole and not specifically Cape Town or the Western Province. So we've already touched on the planning bylaws, and with that typically comes your zoning schemes. And your zoning schemes are the zoning rights or basket of rights that is assigned to a particular property and their particular zoning. These are, example, your residential zonings and your business zonings, public space zonings. These are all classifications given to properties, and then within the zoning scheme, they are assigned rights to them. For example, with your residential zonings, you'll obviously have your right to have a dwelling house. but then in those zoning schemes, they will deal with having an additional dwelling house or a second dwelling house or a third dwelling house as what is allowed in City of Cape Town. Also, that deals with when, in terms of which zonings you can put up your flats, what zoning you need to do your businesses, and then you get additional use rights that also attach to individual zonings. So really the planning bylaw and the zoning scheme encapsulates what basket of rights an owner has and what they can do on that property. So i.e., can they run a bed and breakfast from the property based on the zoning? Can they Airbnb from that property? Can they do a boarding house? Can they do a clinic? So all of those types of answers, you turn to the zoning scheme and the zoning of the property to determine what is that basket of rights. You can also then apply to deviate and add on to those basket of rights as well. The other side of things, which is title restrictions, is separate to your zoning schemes and the basket of rights. And your property can also be restricted under the title conditions. So as I mentioned earlier, historically the developer of your neighborhood or your area, as he applied for his development rights and created those lots, he himself, in most instances, had an idea or vision of what that area or suburb or neighborhood was going to look like. And in order to keep that neighborhood within that particular picture that they had, they would put in title restrictions to say that you can only do a single house or a single building, or you can only build to a certain height. You can do 1 story or 2 stories on particular plots. Building line restrictions, i.e., you can only build to 3 or 4 or 5 meters near to your boundary line. This was also used as a planning tool from the municipality side, so they would also impose title restrictions to this effect as well. This is still open as a function to the municipalities today, but in most instances, because they have an existing zoning scheme, they don't rely on it as a restriction for that sort of basket of rights, but rather they'll use it to impose servitudes or conditions that they need for services, such as right-of-way servitudes or sewer servitudes or pipeline servitudes, and generally just encapsulated as a services servitude. Now, what I want to sort of expand on this item is that nationally this is applicable, and nationally you then have to be aware as to when you are looking to develop a property or change use on a property, you do need to give a consideration to what is contained on the title deed and what constraints are contained therein. And part of that consideration is it still applicable or not? Because a title deed condition, depending on a number of factors such as how it was created, how it was worded, who created it, and whose favor it was created, actually determines in today how you deal with that restrictive condition, and also do you need to deal with it at all. So an example of what I'm trying to say is you can find in a title deed that in 1902 the original owner of the property that now sold it to someone else imposed a height restriction, in the sense of saying that selling this land subject to you not being able to build 2 stories or 3 stories or a block of flats on the property. And they register that condition in the seller's favor. So i.e., John Smith, who sold the property, gives this property over subject to the condition registered in his favor. Now, that is, as I've worded it, is a personal right that was registered specifically in favor of John. If John is no longer around or is deceased, that condition has no party that is entitled thereto, which means that there is no actual restriction on that property. And therefore, when you make your application to build and go ahead and build, there would be no problem in respect of that title condition sitting on your title deed. In turn, if the condition was imposed, for example, in terms of a planning ordinance 33 or 34 in the last 50 years or so, and it was registered in favor of either the municipality or in favor of an owner or owners within a township or neighboring properties, there will be a requirement from the municipality that you make an application in terms of the bylaw, wherein they will notify all of those owners and receive comments from all of those owners, and then take the decision as to whether to approve your removal of your title condition or not. And I've cited a case just after, at the end on the notes here. The reason why I've cited this case is because it is a circumstance in which a property owner, when selling her property, registered a garden servitude over the neighboring portion that she previously owned and sold. And this case, basically, it escalated from the High Court, Supreme Court, all the way to the Constitutional Court. And while the initial condition was registered between herself and someone that purchased the property decades ago, and that person has since unsold and then unsold again. And she obviously was in the position and holding the position that she has a right to a garden on that neighboring property in terms of the title condition. The current neighbor challenged this in court, and in the end, the Constitutional Court actually, on the interpretation of the condition, found that how the condition was created was a personal right between the current owner and the previous owner of the neighboring property, and therefore doesn't apply between the current owner and the current owner of the neighboring property, and therefore the condition doesn't have any force and effect. And this case highlights how important the wording and formulation of title conditions is when trying to make them apply or carry through successes in title. Okay, so now I just want to move on to the city of Cape Town specifically, and what they have sort of done in their amendments or recent amendments in their planning bylaw. So there's a couple of new things that they've added in, one of which that I want to address is the affordable rental housing and affordable flats. Now, it is, from my understanding, that this change, which now allows an owner of a residential one, which is the change from single residential to residential one, zoning of a property, will have the right to build 8 to 12 units of affordable rental flats on their property as an existing use right. So, but this is limited to about 190 areas, specifically township areas. It's where it appears to be limited to. So this means that within your other suburbs, where your property is zoned residential one, you are still limited to having a dwelling unit or dwelling house 1, 2, and 3 on your property as an existing right. But there are, within the township areas, they can do up to 8 and 12 units depending on the size of your sites and services in place. You have an existing right to go ahead and build that. and submit your building plan approval and start building. This is in response to what was happening or already happening on the ground within these areas, i.e. micro developers in these townships and in these spaces were already building these micro units for rental within these spaces. And this adjustment of this part of the bylaw is in response to what was already happening on the ground. And one thing that is noted here is that unlike the other areas where you are restricted to your second and third dwelling, which is something that is happening quite often these days, is where owners are using those rights, sectionalizing those units, and then selling off your third or second dwelling, or even selling off the right to build the second or third dwelling itself. The affordable rental flats are, by its definitions, limited in that they cannot be sectionalized at this point in time, which is an interesting limitation placed, and it's not clear why that limitation is placed at this point in time. And then there are some other interesting changes to the some definitions added in, which is they've added in the new definition, which is for a roof, and they are showing that there's new definitions as to calculating how you get to sort of your top of building and how you calculate or define your ground level. Because at least in the city of Cape Town, it is quite common to find disputes in respect of heights of buildings and protection of views. And there's been now obviously been a nice adjustment to how the municipality is interpreting what is your ground level and what is the top of your building. And then one other item that I think needs to be addressed, which I don't know if some people specifically attended to day 4, is chapter 8A. Is there anybody that specifically showed up today to actually just hear on chapter 8A of the planning bylaw? Nobody. Okay, that is interesting. So before discussing chapter 8A, there's 2 earlier provisions that I just want to highlight before going forward, which is one of the new items added in is section 69A, which deals with powers and functions of a department to promote lawful development. And specifically, what I find interesting here is the subsection 2A and 3, which appears to be addressing a requirement of impartiality that is required from officials when deciding applications, and specifically restricting officials from providing advices on applications that are before them. So this is an interesting point because in practice, I know it is quite common for not just the developers, but for myself as a conveyancer, other professionals such as town planners and architects, to actually to reach out to senior officials from the city to actually find out what their viewpoints are on certain parts of the bylaw, zoning scheme, to get their input when they are sort of putting an application together. Because let's be honest, there will be general gray areas, and you don't want to submit something on behalf of a client and the municipality has a completely different view or interpretation to something, especially those gray area items. And now they've added in this specific item which bars them from giving sort of advices. which I found is an interesting one. And I want to see how this is actually carried out going forward. Another item that I think is interesting is that they've added on additional items under duties of the applicant. And specifically, they've added this item, sub-item 3, which when an applicant provides information, they should provide information which the applicant knows or ought to reasonably know in order, or that the city basically put all the information that you're aware of and ought to reasonably be aware of and hand it over to city when the city needs to make a decision. Now, ought to reasonably know, that will be an interesting one to see how the city actually takes that forward. And I do think that this being added is added for the purposes of chapter 8A, which in chapter 8A is the revocation. So this has a lot of people concerned at the moment, and for obvious reasons. Essentially, the revocation chapter, if in broad terms, gives the municipality the right to revoke an approval that they've already given. Now, previously, or prior to this piece of change in their bylaw, you would appeal internally on your application, and once your internal appeals have exhausted, you can take your matter on review at the court. So it's judicial review. And judicial review in terms of PAJA has a limited area within which the courts can actually interfere or overturn a decision. So it's not necessarily overturning a decision based on the merits of the case, but it's more to deal with procedural irregularities. Now, what they have added here is that when there is a material irregularity in process, and when there is someone challenging the approval on the basis of this material administrative irregularity, the municipality has written a power in for themselves to basically revoke the approval given. They've also written in the power to amend the approval given. And now, for obvious reasons, this is a big concern to the industry as a whole, being because majority of the time, your finance approval for your development or your project is linked to getting your approvals from the municipality for your project, right? And now this new authority written into the bylaw now gives the municipality an opportunity to overturn a decision already given. So it removes a lot of certainty for a developer, for a property owner, for the banks or financiers when giving finance in respect of their developments. So I just wanted to sort of touch on some of these items within chapter 8, which, as you can see, it's got A to M. So it's quite a lot that has been written in. And you can see from what has been written in, there is an attempt to balance what they've added in with giving it as a fair procedure in order to not prejudice completely the owner or applicant, right? And one of those things that I would say that I would highlight that where they've done this in is that they've put in the sense of 122B, outlining the purpose of this chapter, wherein they're doing it sort of without the need to do judicial review, and outlining that if they've identified this error, that they can retake the decision. And what I can say on that one is that if you are a landowner, right, or developer, and you put in your application to develop and you get your approval, and after your approval, it's identified that there was some sort of material irregularity. And it is obvious that should the matter go to court and on judicial review, that it will be overturned. The one of the items in there is that because judicial review will take quite a long time in order to then undo things, and you as a developer know that this is going to be undone in any event, you don't proceed on your approval. But unfortunately, it also means that you are locked in that state until such time that the court makes the decision to overturn. So what has been written in is that it allows the application to, rather than go to court and sit in lengthy and costly proceedings, for it to be overturned. And under 122C, this is linked to where the owner can also consent to these to the revocation. So there is that one positive added in from a landowner's perspective, is that if there is an obvious error, his matter doesn't stand locked in and doesn't go through a costly judicial review before it can be overturned. However, these new amendments go on to allow that even without the consent of that holder of that approval, the municipality can revoke that approval. And one of the concerning parts is that it does not give a time limit for this removal. So, i.e., you as the developer can, or landowner can, receive your approval, get your basket of rights, get your building plan approval, start building, and there is no time limit within which the municipality can start this process and revoke your approval. There is a time limit provided for when the process is initiated by a third party. So this is now your materially affected third party that becomes aware of the decision and then starts objecting to the process and wants to challenge the process, and they try to initiate that procedure or this procedure in the new section. They have within 21 days of being made aware essentially of the decision to submit. So there is that guarding item in respect of third parties that will object to a development or whatever you are doing on site. They have a 21-day period in order to sort of put this or initiate this process. But the real problem does still lie with the fact that the municipality is limited with a time frame of when they can overturn. And this is truly concerning if you look specifically at 122G sub 5, which deals with the procedure for revocation or amendment, wherein that specific item says the city must disregard the state of completion of a building and the activity on the land which when deciding to revoke or amend. Now, that is, in my opinion, a little bit insane, because how do you disregard the amount of capital investment a property owner or a developer has put into the ground when deciding to revoke an approval? Because if you look at the later on clauses, that specifically 122M, the city can end up giving an order to demolish your structure. And that is going to create one hell of an issue when it comes to certainty of putting money into the ground, because you get your approval, you get your building plan approved, you build, com almost complete your building, and then the municipality can revoke its approval and further order you to demolish your structure. Um, that will be concerning to financiers and property developers as a whole. So these are sort of a lot of concerning items that is being discussed by various professionals, obviously within the industry at the moment. And specifically at the Western Cape Property Development Forum, there's a discussion of what we as the built environment professionals should do to address this issue, as we are full well aware that this is a concerning item and will probably affect investment going forward. And I think that is sort of the end of me trying to deal with this item for today. Are there any questions that I can field quickly in the last 10 minutes? Can you give a hands up? No questions? Okay, so what I will say then before we end off is that this is a very difficult topic to cover, especially when nationally, when there's different bylaws fragmenting in different procedures. And if you have any specific questions that relate to your specific area and your specific bylaw, feel free to pop through an email to us and I'll try and address those questions. Title conditions as well. Title conditions are a very, very broad area in respect of they could be imposed in terms of so many different pieces of law and legislation. And what I find is that a lot of people are not aware that the bylaw is not your only mechanism to remove title restrictions. This applies to even some municipal officials are not aware of that as well, because depending on what legislation or how it was created and formed, sometimes those old pieces of legislation have internal mechanisms to remove those conditions, and they are in most instances less burdensome and less cumbersome than the current forms of legislation. Then if okay, so I see a question or two here coming in. So I see there's a question from Fazlan asking how difficult it is to apply for GR2 from CO1 zoning. That is a lengthy answer. Fazlan, can you pop me an email and then we can address that. So one of the items why it makes that lengthy is because community zoning 1 or is going to be property typically that is owned by the municipality. And then one of the legislation pieces that you need to touch on then is the municipal asset transfer regulations as well. And that requires a lengthy answer to it as well. Then I see you've got a question here from Mark on the 8 to 12 rental units. If it's existing now, can it be reconfigured for 12 units or must it be vacant land? So no, it's not limited to vacant land. So if your 8 to 12 units that are built on site fall within that now new adjustment of the bylaw, and you don't, in this instance, which happens with most micro developers without this adjustment, have the necessary approved building plans, you now can submit your building plans for approval. And the City of Cape Town has included mechanisms where you won't be penalized for submitting it now when historically it wasn't in place. I see there is a query asking about how they're going to, how people need to keep track of the forum and the WCPDF forum and its movement on this issue. I think that we will probably have to put updates on the WCPDF website when dealing with this issue, because there will probably also be a call for comment from other parties as well before going forward. Okay, and that seems to be all the questions for today. If there's anything else, please feel free to send us an email and I'll do my best to give you all a comprehensive answer. Okay, thank you all.